Today we have presenting with us Rachel Wentworth. She is the Executive Director of the Housing Equality Center of Pennsylvania. She has 17 years of experience in the fair housing, including test coordination in the areas of rentals, sales, insurance, lending, and accessibility, complaint resolution, fair housing education, and technical assistance to local governments and housing providers, and capacity building for other organizations. Prior to joining Housing Equality Center, Rachel was a test coordinator at the Greater New Orleans Fair Housing Action Center. She holds a Master of Community and Regional Planning from Temple University. Rachel, if you want to take it over.
Okay, thank you. Good afternoon, everybody. As Tori said, we're going to be talking today about some recent new trends in fair housing, most specifically the implementation of a lot of new program rules, new guidance, new regulations that were implemented by HUD during 2016. So I'm going to go ahead and get started. I'll do a brief overview of the Fair Housing Act. I know that a lot of you are very familiar with the Fair Housing basics, but for those of you who are not so familiar, I'll do a quick review, and then I'll get into the new HUD guidance and program rules. And this is kind of a grab bag. I know this is a diverse audience, so hopefully there'll be something for everybody. But I'm going to talk about fair housing as it applies to zoning and land use, criminal records as a criteria for admission into different types of housing, harassment, nuisance ordinances, limited English proficiency, and gender identity. So it's a varying set of topics today, and okay, so I'm going to just first do a brief overview of the Fair Housing Act. What we call the Fair Housing Act is Title VIII of the Civil Rights Act of 1968. That was most recently amended in 1998. And it's the federal law that makes it illegal to discriminate against individuals in any housing-related transaction based on these 7 protected classes. So race, color, national origin, religion, sex, disability, and familial status, which refers to the presence of children under the age of 18 in a household, or anybody who's in the process of adding a child to their household, whether that's pregnancy, adoption. And in Pennsylvania, we have one additional protected class, which is age, and age in the state of Pennsylvania is defined as people over the age of 40. Then there are a lot of individual jurisdictions that have additional protected classes. There are a number of cities and other municipalities in the state that have sexual orientation, gender identity, source of income, and probably a handful of other protected classes. Some jurisdictions protect military status. So it's just important to note that in addition to the federal protected classes, you should always know your municipal protected classes as well. The Fair Housing Act is very broad in the types of transactions that it covers. We tend to think of housing discrimination as occurring in rental and sales transactions, but the Fair Housing Act also covers mortgage lending, homeowners insurance, appraisals, zoning and land use, and it also covers a wide variety of different dwelling types. Obviously apartments, both public and private housing of all types, condominiums. Homeowners associations often like to believe that they're not subject to fair housing, but they are. Dormitories, mobile home parks, homeless shelters, nursing homes, group homes for people with disabilities. Basically anything where a person is living for longer than a very short transient stay, like in a hotel, is going to be covered by the Fair Housing Act. This is just the slide of everybody who must abide by fair housing laws that sort of touches the housing industry in any way. Again, you think about landlords, property managers, realtors being subject to fair housing laws, but there's a wide variety of other entities that are as well. Builders and developers, architects, government jurisdictions, neighbors, maintenance people, basically everyone who is involved in any way in housing transactions. I'm going to just really briefly talk about a couple of more technical areas of the Fair Housing Act generally in this portion, because they'll apply to some of the new rules and guidance that I'll talk about later on. So there are several exemptions to the Federal Fair Housing Act. The first exemption is that owner-occupied buildings that have 4 or fewer rental units, and when the owner does not use the services of a real estate professional like a property manager or a realtor, do not have to comply with the Fair Housing Act. And in the state of Pennsylvania, our law is a bit more restrictive than that. The only exemption under Pennsylvania state law is basically a 2-unit building where the owner lives in one of the units is exempt. A sort of narrow set of for sale by owner situations is exempted under the Federal Fair Housing Act. Housing operated by religious organizations and private clubs may limit their occupancy to members of those religious organizations or clubs as long as the organization doesn't restrict membership based on another protected class like race or national origin or religion. So as long as a religious organization isn't discriminating on another protected class, they can limit housing to their members. Housing for older persons, this is usually talked about as senior housing or retirement housing. In order to be exempt under the Fair Housing Act, it has to comply with a specific definition. The Housing for Older Persons Act defines housing for older persons as either 80% of the households have a resident over the age of 55, or 100% of the residents must be 62 and older. And any type of housing that is going to claim this exemption needs to have in place procedures to ensure that this definition is met. Because if the housing falls off of this definition, they lose their exemption. And this exemption is just for the familial status portion of the Fair Housing Act, so they can't limit their housing based on race or religion or any other type of protected class. Just they can exclude families with children. And there's never any exemption under the Fair Housing Act for discriminatory statements or advertising, either written or verbal. So anyone who is going to discriminate, somebody who is exempt under the owner-occupied exemption, can't advertise in a discriminatory way, and they can't verbally tell people that they're discriminating. I'm going to just briefly talk about reasonable accommodations and modifications. These are, in addition to protecting people from disabilities from outright discrimination based on their disability status, the Fair Housing Act also allows for accommodations and modifications that allow people with disabilities under the Fair Housing Act to occupy and enjoy a dwelling unit in the same way that somebody who would not be disabled could use and enjoy that unit. So reasonable accommodations are changes in rules, practices, policies that would enable that person equal opportunity to use the dwelling. Things, really simple examples of accommodations are allowing assistance animals in no pets buildings, parking, lease applications being in large print, that type of accommodation would be considered a reasonable accommodation under the Fair Housing Act. Reasonable modifications are changes in the actual physical structure of a dwelling. So things like ramps, grab bars, anything that's an actual physical change to the structure is considered a reasonable modification. These are typically in the case of private housing paid for by the tenant, but the landlord has to allow the reasonable modification to take place. In housing that's publicly subsidized, then that cost would be typically borne by the housing provider. So that's a very, very brief on reasonable accommodations and modifications. That's a topic that could take hours in and of itself. So very quickly, because this applies to some of these new things in the Fair Housing Act, is the issue of disparate impact. And this has been an area of the law that's somewhat in dispute, and there was a Supreme Court case that dealt with the issue of disparate impact that was upheld. The concept of disparate impact was upheld by the Supreme Court in 2015. And basically disparate impact means that a policy that is neutral can be considered to be discriminatory if it impacts a particular protected class more than the general population. So a local example of this has been that we've been involved in some situations regarding insurance discrimination where a policy that is seemingly neutral in, for example, homeowners insurance companies refusing to write policies for flat roofs has a discriminatory effect on municipalities and neighborhoods that are primarily Black neighborhoods. So this is a policy by the insurance company that would have a disparate impact on race. That's just an example of where there's case law to support disparate impact being, a neutral policy being discriminatory. So we'll talk more about that later in the context of some of these new pieces of guidance. So the first new piece of guidance that I'm going to talk about is zoning and land use. And just about a year ago, November 2016, DOJ and HUD released an updated version of some prior guidance. And when I've written out these pieces of guidance, you can just, when you get the copies of the slides, you can just Google this exact language to get copies of the actual documents. So the new guidance is entitled Local Land Use Laws and Practices and the Application of the Fair Housing Act. This is designed particularly for local governments to help them understand their obligations when making zoning and land use decisions related to housing that may be occupied by members of protected classes, and it particularly spends a lot of time on group homes for people with disabilities. And for those of you who have seen these HUD DOJ memos, they're a Q&A format with answers to common questions regarding housing discrimination by municipalities under the Fair Housing Act. So the Fair Housing Act prohibits land use and zoning laws, decisions, policies that discriminate or have a disparate impact based on membership in a protected class. So this area of the Fair Housing Act, a lot of these issues that are sort of tangential to the direct provision of housing fall under this otherwise making unavailable or denying housing. That's one of the prohibited practices under the Fair Housing Act. You know, the law lays out specific prohibited practices, but then has this kind of catch-all, otherwise make unavailable or deny category. So zoning is one of these that falls under that. So under the Fair Housing Act, housing is specifically defined not only as buildings that are intended as residential buildings, but also vacant land that may be developed into residences. And I'm going to give some examples of land use or zoning laws or practices that have been found to violate the Fair Housing Act. So any type of policy or decision that treats housing that may be occupied by protected classes less favorably than housing occupied by other residents. Again, this happens most commonly with affordable housing, where the perception is that that's going to be occupied by protected classes, whether that's based on race or disability or some other protected class, or group homes for disabilities. So any type of land use policy that treats that type of housing less favorably is going to be a violation of the Fair Housing Act. Blocking group homes or multifamily or affordable housing in response to neighbors' fears or prejudices against persons with disabilities or racial or ethnic minorities. Requiring any additional studies or procedural steps or unnecessarily delaying decision making when considering a development that may be occupied by members of the protected classes. We see this a lot with group homes for people with disabilities, that the zoning ordinances often require extra steps in order to have a group home approved, as opposed to a similar type of housing that will not be occupied by people with disabilities. Same goes for affordable housing that may be occupied by protected classes, that we've seen delay in making decisions about that type of housing as opposed to market rate housing. Refusing to make reasonable accommodations for persons with disabilities in land use and zoning. So this often comes into place when somebody needs to make a modification to their home that would not conform to the zoning of the district that their house is located in. So we see this a lot with somebody who needs a wheelchair ramp, and to install a ramp would bring that into the setback requirements for that particular zoning district. So that's an example of a situation where somebody would be entitled to a reasonable accommodation to a provision of his zoning ordinance. So again, the disparate impact issue here, a zoning land use or a land use or zoning practice may be found to be discriminatory even if there's no personal bias on the part of government officials. Anybody who's been to a zoning hearing knows that residents come out and can and do say lots of discriminatory things in response to something like a group home being considered in their neighborhood. We have free speech. The residents have the right to come out and make those comments, but the government officials may not take those views into account when they make their decisions. Sometimes zoning entities will have a desire to benefit a particular group, and this can violate the Fair Housing Act if that results in different treatment against another protected class. So we see this a lot with senior housing, where municipalities will want to encourage housing for older persons in their community and will offer density bonuses and other types of incentives to developers of senior housing, but that could cause a different treatment against housing that would be occupied by families, and therefore could potentially violate the Fair Housing Act because of treating families with children differently. So once again, a land use or zoning practice can result in a discriminatory effect, even if it's a facially neutral policy. So we see this in some areas where they have zoning ordinances that contain, for example, very large minimum lot sizes or minimum square footage for new housing, that could possibly have a discriminatory effect based on some of the protected classes if housing that is then going to be very expensive to develop is out of reach for members of the protected classes residing in that region. It can also be considered discriminatory if it perpetuates segregated housing patterns. So we're not going to talk about affirmatively furthering fair housing today. A lot of you are familiar with affirmatively furthering fair housing and the emphasis on making zoning and land use decisions that do not worsen the racially segregated housing patterns that we have in our country. So specifically, one of the areas that we see violations in zoning ordinances are ordinances that discriminate against families with children. So I mentioned previously different use or dimensional regulations for age-restricted versus family housing in the same zoning district. That would be considered treating housing for families with children less favorably than housing for adults. We've seen zoning ordinances where there are certain districts where you can have townhouses or apartments for senior housing, but for housing that is not age restricted, you can only have single family homes. That would be an example of a potential Fair Housing Act violation. We've also seen zoning ordinances that actually have language in the ordinance that explicitly express a limitation on the number of children in the school district. So they'll say, such and such a policy is intended to limit the number of families with children in the municipality. That's a very blatantly discriminatory provision. So like like housing in general, municipalities may designate a zoning district as age restricted. That district needs to comply with the housing for older persons definition. So like I said previously, a municipality would be subject to the same requirement as any other type of housing provider, that they would have to have some type of policy in place if they're going to designate an age-restricted district, to make sure that the district continues to fall within that housing for older persons definition. Okay, group homes. This is the other big area under the zoning portion of the Fair Housing Act where we see violations occur. So the definition of a group home is very flexible. It can include group homes that provide support services, that only provide housing. They can be operated either by individuals or by organizations. They may or may not include supervision of the residents, and they may or may not be licensed under any particular program. Under the Fair Housing Act, people who are in recovery from alcohol or drug dependency are covered as people with disabilities. The Fair Housing Act does not consider somebody to be a person with a disability if they're a current user of an illegal controlled substance. So addiction is a disability. Under the Fair Housing Act, current use is not a disability under the Fair Housing Act. So the general rule of thumb here is that group homes for small numbers of residents housed in single-family homes should be treated the same as any other single-family residents in the same district. So things that we see locally are spacing requirements, requiring group homes to be spaced a certain distance from each other. We've seen spacing requirements as large as half a mile in our region. Greater procedural or other types of burdens on group homes as opposed to other residential uses. We see lots of various rules that apply only to group homes. Enforcing any type of ordinance provisions more strictly against group homes, whether that be zoning or code enforcement that targets specifically group homes. The definition of family can affect group home situations by restricting the number of unrelated individuals that occupy a single family home. It's okay for municipalities to have an occupancy limit on number of unrelated persons who they consider a family, but a group home for people with disabilities is going to be entitled to a reasonable accommodation, to have an exception to this definition if it is necessary for those people with disabilities to occupy that home. Licensing requirements and registration requirements. Some municipalities say only group homes that are licensed under particular programs can be located in their municipality. Some municipalities have registration requirements that require a lot of information about the residents being given to the township. There's some municipalities that say that information has to be publicly available. So those are some other restrictions that we've seen on group homes. And very commonly, zoning ordinances will exclude addiction recovery homes. So we had in the beginning of 2016 a rather noteworthy zoning case that settled in Whitehall Township, which is right outside of Allentown. And This was a HUD complaint where the developer alleged that the township was discriminating because of race, national origin, familial status, and disability when it denied a proposal for an affordable housing complex that was going to be located in the township. So the residents there was a lot of resident opposition to this project. They said that it was going to change the makeup of the area, that it was going to change the character of the neighborhood. And the zoning board denied the project on the basis that there was inadequate parking. This was determined to be a violation of the Fair Housing Act, and the settlement required the township to pay the developer's legal fees, which you can see were pretty sizable, as well as requiring the township to actively promote the project and revising the ordinance to remove barriers to affordable housing. Okay, I'm going to move on to something completely different, from zoning to criminal records. Earlier in 2016, HUD released a piece of guidance on the use of criminal records as a criteria for admission into housing, typically rental housing. So this piece of guidance is basically based entirely on the concept of disparate impact. So this guidance says that although using criminal records as a admissions criteria in housing is a facially neutral policy, that it applies equally to everyone, because of disparities in the criminal record or the criminal justice system in our country. Any type of restrictions based on criminal records are more likely to disproportionately burden African American and Hispanic individuals. There have certainly been advocates who also say this has a disproportionate effect on people with disabilities as well. So this guidance says the Fair Housing Act does not prohibit housing providers from appropriately considering criminal record information when making decisions. They say, you know, criminal records are not a protected class, but arbitrary and overbroad criminal history related bans are likely to have a discriminatory effect, and are not likely to have a sufficient justification to kind of jump over that disparate impact hurdle, that a discriminatory effect that of denying all types of criminal records can't be justified in any appropriate sense, so that would violate the Fair Housing Act. Basically, HUD is saying here that any type of blanket ban would violate the Fair Housing Act. So the guidance steps away from the idea of disparate impact and says that, you know, if you're using criminal records as a pretext for blatant discrimination, that's always a violation of the Fair Housing Act. So if you'll deny housing to African Americans who have criminal records but make an exception to that policy for white applicants, that's just a blatant violation of the Fair Housing Act. And then the HUD memo goes into to the issue of blanket bans. They say that a blanket ban that doesn't take into account personal circumstances at all is going to be a violation. And then HUD throws a wrench in everybody's housing policies, because they've they've said, over and over and over again for years, and we've certainly said over and over and over again for years that you want to have consistent policies that apply to everyone. This HUD guidance says that in the case of criminal records, it is appropriate to make decisions on a case-by-case basis, that providers must consider any kind of extenuating circumstances like the nature and severity of a conviction and the amount of time that's passed since the criminal conduct occurred. So HUD says that you can appropriately consider criminal records, but that blanket bans are not appropriate. Obviously, there's a lot of gray area here, and there's some kind of test cases on this issue that have been pending for a long time with no decisions on those cases yet. So this is very much an emerging area of the law, and we're certainly looking forward to seeing how these cases are decided. So this criminal record guidance also has an exemption. The guidance says that if somebody has been convicted of manufacture or distribution of a controlled substance and a housing provider makes a ban on that particular type of criminal history, they will not be considered to have violated the Fair Housing Act, even if there is a discriminatory effect, a disparate impact that has resulted from the policy. So this exemption is somewhat limited. It's a conviction only for manufacture and distribution. It doesn't include an arrest without conviction, and it doesn't include a conviction for possession. So that's the exemption to the criminal record guidance. Okay, harassment. Last September, HUD published a final rule on quid pro quo and hostile living harassment, hostile living environment harassment. This really clarified what situations a housing provider was going to be liable for harassment under the Fair Housing Act. So quid pro quo harassment is a something for something. The maintenance man approaching the female tenant and saying, I will fix your water heater if you do some sort of sexual favor. Hostile living harassment is any type of unwelcome conduct based on a protected class that deprives that person of the use and enjoyment of their housing. And we usually talk about quid pro quo and hostile living harassment in the context of sexual harassment, but it's also important to note that this could be harassment based on race or national origin as well, that this guidance applies to those types of harassment as well. So this memo this rule just clarified some previously unclear areas of the law and clarifies the following issues. So the new rule says that any unwelcome request or demand may constitute quid pro quo harassment, even if the victim acquiesces to that request or demand. So the tenant who's offered, some type of benefit in exchange for sexual favors this is still considered illegal harassment, even if that tenant would agree to the demand or request. Hostile environment harassment doesn't require any type of change in the actual conditions of the housing or the terms of the housing to be considered illegal harassment. Neither psychological or physical harm must be demonstrated to prove that a hostile environment exists. And harassment can be written, verbal, or other types of non-physical conduct. It doesn't require physical conduct to be considered illegal harassment. Then this last item is an area where the Fair Housing Act diverges from other types of civil rights laws. Typically in areas like employment, it's been found that hostile environment requires more than one incident of harassment. You know, employment cases have been considered to be conduct not rising to the level of discriminatory conduct if it's only one incident of harassment. But this new rule basically says that in a person's home they have a higher expectation of personal safety and comfort. So if somebody's home and housing are affected by harassment, that a single incident of harassment can constitute a hostile living environment in a housing context. The other thing that this harassment rule addresses is housing provider liability and what situations the housing provider is liable under the Fair Housing Act for harassment. So obviously the housing provider is liable for its own conduct, but it is also liable for failing to take prompt action to correct and end discriminatory housing practice by its employer agent, so the maintenance man, for example, where it knew or should have known of the discriminatory conduct. I'm going to skip down to the third bullet point and just say, in general, the housing provider is always, basically in all circumstances, whether or not they knew or should have known of the harassment, the discriminatory housing practice, they're always liable for the actions of their agents or employers. So this really clarifies the extent of the liability for housing providers. It's, you know, this is again, it's a broad interpretation of what the responsibility is for the housing provider to prevent harassment. The other thing that this clarified was that the housing provider also has responsibility to correct and end discriminatory housing practices by a third party. So the obvious example of this is a neighbor. If a neighbor is harassing a tenant because of a protected class under the Fair Housing Act, the housing provider has the responsibility to correct it, or they could be liable under the Fair Housing Act. Okay, the last couple of these are quick to get through. So HUD also released guidance on nuisance and crime-free housing ordinances. And these are the types of municipal ordinances where if somebody calls 911 3 times in a month, then they're not, the landlord needs to evict them, something like that. So this is any type of ordinance that penalizes residents for 911 calls in situations where that person is in need of protection from domestic violence or another crime. So this guidance says that these nuisance and crime-free housing ordinances violate the Fair Housing Act when they have an unjustified discriminatory effect or are enacted or enforced intentionally to discriminate because of a protected characteristic. Again, the most common situation where we've seen these is where these nuisance ordinances have a discriminatory effect on individuals who are experiencing domestic violence. And the example that is local, probably a lot of you heard of this. It was, all over the national news a couple of years ago that the borough of Norristown had a complaint that was settled where they had an ordinance that if the police are called to a property 3 times, that the landlord would be fined $1,000 a day if they didn't evict that tenant. So there was a horrible situation where a resident was threatened with eviction after she had called the police several times when an ex-boyfriend who had been abusive entered her home. And then she had her abuser returned, very seriously injured her, and the neighbors called the police. The resident at that point was unwilling to call the police out of fear of being evicted, and the neighbors called the police, and the landlord was forced to evict her. So that was again a HUD complaint, I believe. May have been a lawsuit, I can't recall at the moment, but that was considered to be discriminatory behavior by the municipality. Okay, this is a quick and easy one. HUD released guidance on the issue of limited English proficiency. Basically, what this piece of guidance says is that limited English proficiency is so closely linked to national origin and sometimes race that they're pretty much impossible to separate. So any type of discrimination based on limited English proficiency is going to be treated as national origin discrimination. And further says that rules that require English proficiency in tenants are used as a proxy for national origin discrimination, that the purpose of that type of rule is to discriminate based on national origin. So again, we have a little bit of a divergence with other types of civil rights laws. In an employment context, it's been ruled that sometimes it is legitimate to require employees speak English in various employment situations, but the HUD guidance says that this is not applicable to housing or other housing-related transactions, that those reasons for needing English-speaking employees don't carry over to a housing context. And finally, gender identity. This is a program rule, so it applies only to HUD-assisted programs, and this is anything from shelters to FHA loans, any program that receives HUD funding. That this rule requires that in HUD programs, individuals are to be placed in accordance with their gender identity. This especially applies in a shelter context. There's no requirement for individuals that are in those programs to prove gender identity. No types of verification is required, no invasive questions. Providers are required to update policies and procedures to reflect these new requirements, and non-discriminatory steps must be taken to address any safety or privacy concerns of transgender participants. Again, this applies mostly in shelter situations, but participants may not be required to accept any accommodations. So again, this applies to HUD-funded programs, not other types of private housing. And then I'm going to just skip ahead. This is the conclusion of the summary of all the new HUD guidance. I'm going to just skip ahead to contact information for follow-up questions that may come up after the 8 minutes I have left to answer questions. And I'm just going to go ahead and answer the questions that have come in.
Great, thanks, Rachel.
Oh, you're welcome. I have a question about whether harassment can go the other way around. That is, could the tenant harass the owner-manager? This is actually really interesting because we got a call about this in our office recently. We actually got a call where a tenant was making racist comments to their landlord. So we have seen this happen occasionally. Apparently, tenants harass their landlords based on a protected class. In that case, the tenant isn't a provider of housing, so they're not, they're not subject to Fair Housing Act requirements because they, they're not providing housing to the landlord. But it's interesting that question should be asked because we did just get a question about that. So I have another question about the criminal records issue. It would be hard to argue disparate impact in a rural area with few minorities. I think that is true. And so far we are seeing as people are starting to file these complaints that HUD says this is a fair housing issue. HUD says that disparate impact based on race is the issue with blanket bans on criminal records. So HUD has been saying when people have attempted to file complaints alleging blanket bans on criminal records, if the complainant is white, HUD has been rejecting those complaints. So HUD has said that this has, I believe they have accepted some complaints where disability discrimination is alleged, but you're right that a landlord that is basically renting in an all-white area with a blanket ban and a tenant files a discrimination complaint against them is probably not going to be successful, just based on what we've seen so far. Since this guidance has been in place, HUD has not been accepting those complaints. Okay, so I have another just comment. Following the Northtown case, Pennsylvania changed state law to forbid municipalities from enforcing any part of an ordinance that penalizes residents for calling for emergency assistance. Just a comment on that. I know that some of the municipalities definitely do still have these on the books, but that's great to know that Pennsylvania at least forbids the enforcement of those ordinances. We've gotten some allegations about municipalities continuing to enforce them, so there certainly may be some of this conduct that's continuing. I have a question. Can we have a copy of the presentation? I think Tori said that she would be sending it out. Is that correct?
Yes, that's correct. We will be sending out the presentation next week
Okay.
along with the recordings.
Okay, great. And I have a question about, is arson considered under the blanket ban? So when HUD is talking about a blanket ban, they're basically talking about a ban on, a landlord who says, I will not rent to anybody who has any type of a criminal record, a conviction for anything, any felonies, any misdemeanors, arrests for anything. A blanket ban is banning all types of criminal activities. So in a situation where a landlord has a tenant who applies for a unit and has either an arrest or conviction for arson, the HUD guidance is saying that the landlord is permitted to appropriately consider the criminal record. Is that person truly based on their criminal record, are they truly a danger to other residents or properties? So in that case, the landlord would need to take into account things like, was it actually a conviction or was it just an arrest? How long ago was it? What were any other circumstances that HUD says the landlord considers the case by case, the all of the issues surrounding that incident, and then make a decision about whether that person is a threat or not. So HUD does explicitly say landlords may appropriately consider criminal records. And okay, then I have a general question about assistance animals and about when a landlord is permitted to ask for verification. So for any reasonable accommodation, assistance animals included, HUD has kind of 3 sets of rules for when you're permitted to ask for verification. The first situation is a resident where the disability and the need for the accommodation are very clear and apparent. So the example of that is a blind person with a guide dog. You as a landlord can see that person has an obvious disability. The assistance animal serves an obvious need for that disability. So in that situation, a housing provider is not permitted to ask for verification since both the disability and the need are obvious. In the situation where a disability is obvious but the need for the accommodation is not obvious, a landlord can ask for verification of the need for that accommodation. In a third situation where the person has a disability that is not visibly obvious to the landlord or is not known to the landlord for some other reason, and the accommodation is also not obvious, a lot of emotional support animals fall under this category, then the landlord is permitted to ask for verification. So a landlord or other housing provider can ask for some type of verification that the person has a disability and the need for the accommodation is legitimate, but they can't ask for any questions about the nature and severity of the disability. So they can require that a doctor or some other professional that's working with the prospective tenant write a letter verifying that they have a disability as defined by the Fair Housing Act, and that the requested accommodation is necessary for them to enjoy the housing, but they can't ask for things like what is your specific diagnosis or anything that would be like personal medical information. So I think this is all the questions that I've gotten, and my phone number is up here, my email is up here. If you had questions that you didn't get answered or you think of anything in the next days, weeks, months.
Great. Thank you, Rachel, so much. And thanks so much for getting on this webinar today,
All right.
everybody. This concludes the webinar.
Thank you.
Thanks again. Bye.